Do you understand that you have the right to have a contested hearing and make the state prove the allegation that you violated, and you're giving up that right?
Yes.
Okay. Is anyone forcing you or threatening you to admit the violation?
No.
Thank you so much. Is anyone promising you anything to make you admit the violation?
No.
Are you satisfied with the services of your lawyer?
Yes.
Did he answer all of your questions?
Yes.
Have you had any drugs, alcohol, medicine, or any type of substance in the last 24 hours?
No.
I have a score sheet, and it shows 16.1 total sentence points. Any objections?
No objection, Your Honor.
Ma'am, are you admitting the one allegation that you violated your probation?
Yes.
I accept your admission. I find it was freely and voluntarily made. In accordance with your agreement, the court finds that you're guilty of violating your probation based on your admission, but the court will withhold adjudication or continue to withhold adjudication on the original charges.
Thank you, Your Honor.
Yes. Probation is reinstated and modified. You'll still have to complete all of the original terms and conditions. The modification is to add the following. 2 AA or NA meetings per week. You'll have to provide proof of that to your probation officer. And there will be a suspended 5-year prison sentence. So if you were to violate your probation, you'd be facing that prison sentence. Do you understand that?
Yes.
Okay. And then the court will impose the following additional costs: $100 VOP cost of prosecution fee, $100 cost of defense, and a $50 application fee. Did I cover everything?
It's everything for defense, Your Honor.
All right. Ma'am, do you have any questions about anything I said?
I do not.
Okay. So you have 30 days to appeal the order of the court. If you cannot afford a lawyer, I'll appoint one for you. Good luck to you. Please see the probation officers there on the front row.
Thank you.
And then you'll have to leave here and go straight to their office today, okay?
Okay, thank you.
Thank you.
Judge.
Thank you. All right. Just one second, Mr. Ballack. I'm just filling out the paperwork.
Can we ask the state to waive some probation? Can the state send something to collections or waive the fines? So waive some of the probation fines?
Do y'all need more time? Because I am running so far behind and I really need to get the docket going. So do you want to go in the attorney-client room and talk some more and then we'll call you back
I
out?
think his only issue was sending some of the money to collections, but I've already talked to the state and they're not willing to do that.
All right.
Okay. I don't want to rush anybody. I just, if you need more time, by all means.
Now, on the misdemeanor, we'll talk about that. The misdemeanor.
Time served.
Wait, it's time served?
90 days.
I signed the 90 days.
What I'm probably going to do is need to put you in the attorney-client room.
I'll sign it. I'll sign it.
No, I'm not trying to rush you at all. I want you to have all the time you need to go over everything, but
Understand.
I am running very far behind, so I just want to
Understand.
give you a little more
Okay.
time so I can call another case.
Bomb me out.
Sir, you're not allowed to talk to anybody.
Your Honor, I believe we're ready.
Oh, you're ready, okay.
So we've got two
Seriously, I'm
cases.
not trying to rush you at all.
Okay.
Okay.
This is State of Florida versus Robert Dunaway. He's got 2 cases here, 1 felony, 26 CF 341, and 1 misdemeanor, 26 MM 1121. He's going to plead no contest to both. We have a written plea with the terms here.
I'm bonding out on the misdemeanor. We're gonna get the video and all that. I'm
What
bonding
now?
out on the misdemeanor.
Okay.
I have time served.
So it sounds like there might be some need to talk some more about
You can
it.
talk to him in the back.
Yeah, just let me know when you're ready.
Sorry about that, Aaron.
No problem.
You guys have address to do? No. I have address. Did I do it?
Desmond Cook is gonna be up next.
Okay.
I've got it out of custody. I don't know if I should take Ms. Byers, but. Good.
Okay, let's take Ms. Byers and she can get on
I didn't
her way.
realize
And then
nobody else had
Mr.
out of custody.
Mr. Cook will be up next.
Under Steve Medina with Dawn Byers. Ms.
Yes.
Byers is 22 CF 1606 and 23 CF 341.
Yes.
We have a VOP agreement. It would be with a withhold of adjudication, and the termination of probation would be by expiration, not by revocation. I don't think there has to be a score sheet, but if we have to have one, we can provide one. May I approach? Your Honor?
Yes.
I didn't sign that yet.
Go. Sorry. You ready to sign that, right? Sorry, Judge.
No problem.
Thank you.
You're welcome.
May I approach, Judge?
Yes. Thank you so much.
And this is really just monetary for her, Your Honor?
Yes, I saw that, and I'm just pulling up.
My
the-
understanding is no restitution, it's strictly court costs and fees.
Yes, I'm just trying to find the affidavit, and I think it's in the other case.
The judge is going to want to make sure you understand the violations.
Okay, here it is.
This is your paperwork, okay?
All right, Ms. Byers, if you'll please raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth? If so, say, "I do."
I do.
Thank you, ma'am. You can put your hand down if you'll just tell me your name.
Dawn Byers,
All right, and could you spell your last name for me?
Byars.
All right. You're here in case 22 CF 1606 and 23 CF 341 on allegations that you violated your probation. And I'm looking at the affidavit that was filed on January 30th, 2026, and it has 4 different allegations, and all of them have to do with failing to pay court costs. Well, the first 3 are failing to pay court costs. Allegation number 4 is community service, failing to complete community service.
Your Honor, I was asking her about that. I apologize. I did not intentionally misstate, but I did misstate. She indicates that maybe that was converted or would have been converted to monetary, but it hasn't been satisfied, so it's part of
Okay.
the admission.
Okay, and then I'm looking at all right, the one I just read from is in 22 CF 1606, but then in 23 CF 341, there is a different affidavit, also filed on January 30th. This one contains the following allegations. There are, I believe, 6. Failing to pay cost of supervision, failing to pay court costs, failing to, multiple ones of failing to pay court costs, failing to pay drug test fees, And, okay, I guess there's not a community service in 23 CF 341. It's all financial in that case, is what it appears from this affidavit. So the community service is only in 22 CF 1606, and the remainder of the allegations in both cases are financial. So, ma'am, have you had a chance to talk to your lawyer about the allegations that you violated probation in both of those cases?
Yes, ma'am.
Have you discussed any possible defenses with your lawyer?
Yes, ma'am.
Did you discuss this agreement with your lawyer?
Yes, ma'am.
Did you read and sign the agreement?
Yes, ma'am.
Is that your signature on the back?
Yes.
Do you understand the rights that you give up whenever you admit to violating your probation?
Yes, ma'am.
Do you understand you have the right to have a contested hearing and make the state prove the allegations?
Yes, ma'am.
And that you're giving up that right?
Yes, ma'am.
All right. Is anybody forcing you or threatening you to make you admit the violations?
No, ma'am.
Has anybody promised you anything?
No, ma'am.
Are you satisfied with the services of your lawyer?
Yes, ma'am.
Have you had any drugs, alcohol, medicine, or any type of substance in the last 24 hours?
No, ma'am.
Are you admitting all of the allegations in both of those affidavits?
Yes, ma'am.
I accept your admission in both cases. I find it was freely and voluntarily made. And it looks like probation is terminating. Let me look at that notice to appear. Looks like we are past the term date.
Yeah.
Okay.
That's
So-
my understanding. I think she took 18 months on May 21st, 2024, so we're past the 2-year point.
All right, so the court, in accordance with your agreement, will maintain the withhold of adjudication. Looks like you're only on probation on the felony counts. That's the only count in 22 CF 1606, and then it would be count 1 in 23 CF 341. Both of those were adjudication withheld. According to the agreement between you and your attorney and the state, that will be maintained. All monetary obligations for court costs and PD fees are to be sent to collections. I'm imposing the following additional court costs and PD fees. That would be $100 per case for a total of $200. And then that's for violation of probation, cost of prosecution, $100 per case for cost of defense, and then a $50 application fee in 22 CF 1606. And it says on here, waive cost of supervision, including arrearages. Is probation okay with that?
Yes.
All right, so your cost of supervision, including the past due amount, is waived. Does that include the drug test fees? I think I saw some of those. No? Those will go to collections then. Okay, so, and what was the amount of the drug test fees? I think it's, actually, it's in the affidavit. It says $65?
Yes.
Okay, so the $65 for drug testing fees would go to collections.
Your Honor, may I make a
Yes.
suggestion just for clarity? And it is complicated, but if we could strike through PD before fees, then it'll be written correctly. It'll cover fees for drug testing as well as PD fees.
There's a dollar amount on there. It says $250 for PD fees.
Oh, no, I'm talking about for the past ones that are going to go to collections. I'm not talking about the.
Oh, I see.
current.
Okay.
It talked about.
Yes, I see it.
Court costs and fees going to collections.
I-
So it could just say court costs and fees instead of court costs and PD fees.
I got it. And what I did was, where it says monetary obligations for court costs and where it said PD fees, I scratched out PD and said all.
Yes, Your Honor.
Okay.
Thank
All
you.
fees
Right.
are going to collections. That would include those drug testing fees. I've already announced the new court costs in each case. Cost of supervision, including arrearages, is waived. And you are sentenced to time served. Looks like your probation's expired. So all of the financial obligations are going to collections, like the court costs and fees, that's likely going to suspend your driver's
It's
license.
already there, so.
Okay.
I'm working on getting that handled, so.
Okay, so, ma'am, you have 30 days to appeal the order of the court. If you can't afford a lawyer, I'll appoint one for you. Good luck to you, ma'am. Thank you.
Thank you.
Thank you, Aaron.
Thank you.
Desmond Cook is up next.
All right, good afternoon. Could you tell me your name, please?
Desmond Cook.
Thank you, Mr. Cook. You're here in 24 CF 2220, and my paperwork shows you don't have a lawyer in this case. Would you like me to appoint one for you?
How long would that take?
I'm sorry?
How long would that take?
Momentarily, there are lawyers right behind you. I would appoint one.
Yes, ma'am.
Okay, I'm appointing the Office of the Public Defender. You're here on allegations that you violated your probation, and I'm going to pull up the case. And I've got Mr. Koch, he's an attorney. He's standing next to you.
Yes, Your Honor. If I may ask, who's the current offer, Mr. Cook?
This is his second VOP. This VOP is due to a new law, petty theft violation. His first VOP, when he pled out, he maintained his withhold. It's at lowest permissible sentence of 16.40 months now. Restitution has been ordered amongst various other things that he has not paid or done anything on. The state at this time would be seeking guidelines.
And that was 6-0.
16.40.
Thank you.
Sorry.
16.40, thank you.
So it looks like there's one allegation in the affidavit. It was an affidavit of violation of probation filed on March 6, 2026, and it is a new arrest. That case number for that new arrest is 26MM316. It's a petty theft case. So,
Yes, Your Honor.
sure.
I'm going to continue this out because you have to talk private.
That's it. Yes, what's the?
That's the other 16 months, but I want to talk.
So the next court date is going to be July 21st
July 21st. Yes, Your
at
Honor.
9 o'clock. And if you work out a resolution, you can always bring in the case sooner. I'll get it in as soon as I can.
Yes, Your Honor, I'll enter denial this afternoon for my client.
Okay.
And I'll come speak to you privately at the jail.
Red Sweater's good.
Thank you.
Robert Dunaway's back.
All right. We have Mr. Valek present. We're recalling Mr. Robert Dunaway, 26 CF 341. And he is present.
Yes, Your Honor. State of Florida versus Robert Dunaway, 26 CF 341. He's here to enter a plea. We have a signed agreement. He'll plead no contest to the reckless driving with serious bodily injury, be placed on probation for 5 years. He'll pay restitution in the amount of $36,917 to Thesalia Nunez with minimum payments of $620. He'll waive the cost of prosecution. We're responsible for $515 in court costs. Probation may terminate early upon full payment. He will also have no contact with the victim, Thesalia Nunez or Erilyn Nunez. He's reviewed, signed, and passing it up with the score sheet.
I'm sorry, the other victim is Alyssa. Alyssa Nunez.
Thank you very much. Thank you.
Let's see. Can I take one?
When will those monthly payments of $620 start?
I informed the victim July.
Okay. Is that feasible to start in July? Because,
July 15th? Could we do that?
I have no preference on when in July.
Okay.
but, I mean, I just want to make sure that I put a start date because it's June 16th right now,
Yeah.
so.
Can I ask the state to set it up to August 1st or somewhere around, or the month of August? That gives me a running start.
The minimum monthly payment is triggered off of the 5 years, so I don't know how much wiggle room we have there.
So if it starts later, then you're not going to be able to pay it off in
I didn't
time.
say I wouldn't be able to pay it, but I was trying to make some comfort room for myself, as best I can. But yeah, July's fine.
So maybe July 15th and every 15th.
As long as it's the month of July.
Yes, ma'am.
I think probation's fine as long as it's paid within the month of July.
Yes, ma'am.
Okay. I just wanted to ask because June's half over, so I didn't know if he was supposed to make a payment for June. That was just clarifying, so he doesn't violate right off the bat or something without realizing. So, okay. So payments are starting in July. First payment due in July. I wrote that on here. First payment due in July. All right, Mr. Dunaway, if you'll please raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth? If so, say I do.
I do.
Thank you, sir. You can put your hand down if you'll just tell me your name.
Robert Walter Dunaway.
Thank you. You are charged with 1 count of reckless driving causing serious bodily injury. That's a 3rd-degree felony with a maximum penalty of up to 5 years in prison. Have you had a chance to talk to your lawyer about that charge and any possible defenses?
Yes, ma'am.
Have you discussed this plea agreement with your lawyer?
Yes, ma'am.
Did you read and sign the agreement?
Yes, ma'am.
Is that your signature on the next to the last page?
Yes, ma'am.
Do you understand the rights that you give up when you enter a plea?
Yes, ma'am.
Do you understand you're giving up your right to go to trial in this case?
Yes, ma'am.
Are you entering the plea freely and voluntarily?
Yes, ma'am.
Is anybody forcing you or threatening you?
No, ma'am.
Has anybody promised you anything?
No, ma'am.
Are you satisfied with the services of your lawyer?
Yes, ma'am.
Have you had any drugs, alcohol, medicine, or any type of substance in the last 24 hours?
No, ma'am.
I have a score sheet and it shows 6.6 total sentence points. Any objections?
No, Your Honor.
Is there any exculpatory DNA?
No, Your Honor.
I do find a sufficient factual basis based on my review of the arrest report. Sir, if you're not a U.S. citizen, do you understand you could be deported?
Yes, ma'am.
If you're not a citizen, do you understand you could be deported?
Oh, yes, ma'am.
All right, and I have not looked at these statutes in a while, so I'll have to rely on the attorneys, but is there also a driver's license suspension associated with this?
Yes, that's my understanding, Your Honor. The state doesn't object, the state obviously doesn't object to a hardship license or whatever, but I don't think the state has any choice as to
Yeah, I
a
think
driver's
it's
license suspension.
statutory, so are you aware your driver's license is probably going to be suspended as a result of this charge?
Yes, ma'am.
Okay. How do you plead to count 1?
No contest.
I accept your plea. I find it was freely and voluntarily entered. Let me ask the state, did the state have a discussion with the victim?
Yes, Your Honor.
Okay, just making sure. In accordance with your agreement, adjudication of guilt is withheld, and you're placed on probation for a period of 5 years.
With early termination.
The court is ordering restitution in the amount of $36,917 to be paid to Thessaly Nunez, and her address is in this plea agreement. The minimum monthly payment, as we discussed a few minutes ago, is $620 per month. The first payment must be paid within the month of July 2026. Cost of supervision is waived. Let me clear that with probation. Probation, are you okay with that? Okay. That'll help you to devote that money towards the restitution payment. That'll save you $40-something a month. The court is imposing $515 in court costs. Is that the correct amount, Madam Clerk? 515? I'm checking on the court costs. I will circle back to the court costs in just a... No, that's no problem. Probation may be terminated early upon full payment of restitution. Does that include court costs as well, need to be paid off? I would think so.
Yes, sir.
Okay, so that would be full payment of restitution and court costs. No contact with the victims, Thesali and Alyssa Nunez. And let me verify those costs. So, sir, I'll circle back to the cost in just a second. You'll have 30 days to appeal the order of the court. If you cannot afford a lawyer, I'll appoint one for you. So you'll need to see, well, ordinarily, I would say you'd need to see probation before you leave the courtroom, and you probably still do, but I understand that, well, is he getting out upon entry of this plea, or is?
He's planning on bonding.
Okay,
Yeah, I have a misdemeanor charge as well.
Okay.
And I'm gonna make bond on that misdemeanor charge today.
okay. So you'll need to see the probation officers. They're sitting right there on the front row before you leave the courtroom. And then, once you bond out, you need to be at the probation office. If you bond out late in the day, you have to be there the first thing in the morning, the next business day. If you bond out in the morning, you need to go straight to probation that very day.
Yeah, right.
Okay?
Yes, ma'am.
So, let me just check on that. Okay. Okay, so, whatever the mandatory court costs that the court is required to impose under the statute, the court is imposing. Right now, Madam Clerk tells me it's $515, but
If it's different.
that's subject to review. So whatever the standard or statutory court costs that the court's required to impose will be imposed. Okay? All right, so any questions, sir?
I think
All right.
probation might need a copy of the plea.
Oh, yes, they probably need to, can you take that and let them take a picture? Thank you.
Good, next up is Ernest Harris, that's Mr. Gates.
Yes, Your Honor. I'm going to Your Honor,
Okay?
including Mr. Cruiser. I've got some witnesses.
Okay, so this is Mr. Ernest Harris III?
Yes, Your Honor.
All right, bless you.
At this time, we're going to hear a denial on Mr. Harris's cases. We're looking at mental health court.
Okay, so he actually has 3 cases, so
Yes, sir.
there's 2020 CF 96 and 21 CF 265. Those are on the docket, but I saw another one that he's been served with the warrant, but it's not on the docket and there wasn't a court date set. It's 22 CF 1797.
What is
This is
This
Ernest
is another VOP that they have.
V. Harris III, 22 CF 1797 is the third case. Thank you. So,
It's a VOP.
Mr. Gates, you want that July date?
Yes, Your Honor. We could do, I think July, is it July 16th?
21st.
21st, that'll be fine, Your Honor.
July 21st, 9 o'clock, and there's a denial entered in all 3 cases. All right,
Susan is going to
Thank you.
from mental health court.
Sean
okay?
Hartsook is next.
And I'll talk
all right.
to
Mr. Sean Hartsook, 25 CF 1962, and he's present.
Yes, Your Honor, this is Mr. Hartsook before the court. We have a plea agreement to be filed in Mr. Hartsook's case, if I can get him to sign for it.
All right.
It's all the same as mine, right?
Not much.
right, Mr. Hartsook, if you'll please raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth? If so, say "I do."
I do, Your
Thank you,
Honor.
sir. You can put your hand down if you'll just state your name, please.
Sean Michael Hartsook.
Thank you.
You're welcome, Your Honor.
Your Honor, we don't have a score sheet, but it will not be a downward departure in Mr. Hartsook's case.
Okay, will we get one? You printing one?
Yes, ma'am.
Thank you so much. Okay, so, Mr. Hartsook, you're here in 25 CF 1962 on allegations that you violated your probation, and I'm looking at an affidavit that was filed on April 8th, 2026. It has 4 allegations that you violated your probation. Have you had a chance to talk to your lawyer about those 4 allegations and any possible defenses?
Yes, Your Honor.
All right. Have you discussed this plea agreement with your lawyer?
Yes, Your Honor.
Did you read and sign the agreement?
Yes, Your Honor.
And is that your signature on the second page?
Yes, ma'am.
All right. Do you understand the rights that you give up when you admit to violating your probation?
Yes, Your Honor.
Do you understand you have the right to have a hearing and make the state prove that you violated, and you're giving up that right?
Yes, Your Honor.
All right. Are you being forced or threatened?
No.
All right.
No,
Has
Your
anybody
Honor.
promised you anything to
No,
make you
Your
admit?
Honor.
All right. Are you happy with the services of your lawyer?
Yes, Your Honor.
All right. Have you had any drugs, alcohol, medicine, any type of substance in the last 24 hours?
Nope.
And the score sheet will be provided soon, but your attorney has reviewed it and has stated that you don't score prison, so I'll sign that when it gets here. But are you admitting to all 4 of the allegations that you violated?
Yeah, I didn't report one time, so yeah.
Okay.
There's no reason trying to fight it.
Okay, I accept your admission. I find it was freely and voluntarily given in accordance with your agreement. Looks like you were already adjudicated guilty on the charge. The court finds that you're guilty of violating your probation based on the admission. Probation is revoked and terminated, and you're sentenced to 9 months in the Okaloosa County Jail with credit for time served. And in addition to any previously imposed costs and fees, there's a $100 cost of prosecution fee, $150 cost of defense. That includes the application fee. And you'll have 24 months after you get out to pay all of your outstanding fees and costs before they go to collections. Once they go to collections, that is going to probably suspend your driver's license. So I would encourage you to get those taken care of as soon as you can. And you have 30 days to appeal the order of the court. If you can't afford a lawyer, I'll appoint one for you. Good luck, sir. Thank you.
You're welcome, Your Honor.
Thank you.
You good?
Christopher Coozer's next.
Yes, Your Honor.
Coming. All
I'm
right.
going to go ahead and handle Mr. Kuzer, Your Honor. We do have witnesses here that have been here all morning that have other places to be, so I want to try and get this.
Yes. Just
I
one
realized
second. I'm making-
earlier, we didn't have Mr. Kuzer enter a plea when we took some of that
Yes.
testimony, so we'll go ahead and file the plea agreement, Your Honor.
Okay.
It'll be a plea straight to the court. 6/16/26.
So this is Mr. Christopher Kuzer. We're recalling his case. I heard some testimony earlier from a doctor who had to leave and was only available at that time. This is case number 22 CF 829. That's a violation of probation case. And then a new law case is 25 CF 1514. And I have Mr. Kuzer is present.
Let me look at it. Yeah. Let me see the score sheet. I gotta change that on here.
I can make one change, Your Honor.
Sure.
The state provided a subsequent score sheet that actually lowered his score.
Okay.
If I may approach, Your Honor?
Yes. Thank you so much. right, Mr. Kuzer, in case 22 CF 829, well, let me swear you in first. Raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth? If so, say I do.
I do.
Thank you. You can put your hand down if you'll just state your name, please.
Christopher Lee Kuzer.
Thank you. In 22 CF 829, it's alleged that you violated your probation. I am looking at the amended affidavit filed on July 25th, 2025. And let me just confirm with probation, that's the most recent affidavit?
Yes.
Okay. And that affidavit contains 11 allegations that you violated your probation. Have you had a chance to talk to your lawyer about the 11 allegations that you violated your probation?
Yes, Your Honor.
All right. Then in case 25 CF 1514, you are charged with 1 count of possession of a controlled substance. That's a 3rd-degree felony with a maximum penalty of up to 5 years in prison. 1 count of possession of a controlled substance less than 20 grams of cannabis. That's a 1st-degree misdemeanor with a maximum penalty of up to 1 year in jail. 1 count of resisting an officer without violence. That is a 1st-degree misdemeanor with a maximum penalty of up to 1 year in jail. And then 1 count of possession of drug paraphernalia, also a 1st-degree misdemeanor with a maximum penalty of up to 1 year in jail. Did you have a chance to talk to your lawyer about those charges in 25 CF 1514 and any possible defenses?
Yes, Your Honor.
All right. I've been handed a plea agreement. Did you read and sign the agreement?
Yes, ma'am.
Did you discuss it with your lawyer?
Yes, ma'am.
I think the state has not signed it.
It's a plea straight up, and I don't think they need to
Okay,
sign
that's
that.
true. Mr. Kuzer, is that your signature on the last page?
Yes, Your Honor.
Do you understand the rights that you give up when you enter a plea in a new case?
Yes, ma'am.
Do you understand you're giving up your right to go to trial?
Yes, ma'am.
And I'm specifically referring to 25 CF 1514. Do you understand you're also giving up your right to remain silent and not incriminate yourself?
Yes, ma'am.
Do you understand you're giving up your right to plead not guilty and have a trial by jury?
Yes, ma'am.
Do you understand that you're giving up the right to have the state prove that you're guilty of these charges beyond a reasonable doubt?
Yes, Your Honor.
You're giving up certain other constitutional rights as well. Do you understand that?
Yes, Your Honor.
Knowing that you're giving up all of those constitutional rights, do you still wish to proceed with a plea in 25 CF 1514?
Yes, Your Honor.
And do you understand that by admitting to a violation of probation, you're giving up your right to have a hearing and make the state prove the allegations that you violated?
Yes, Your Honor.
Are you entering the plea freely and voluntarily?
Yes, ma'am.
Is anybody forcing you or threatening you to either enter a plea in your new case or admit the violations in your violation of probation case?
No, ma'am.
Has anybody promised you anything to make you do either of those things?
No, ma'am.
Are you satisfied with the services of your lawyer?
I am.
Did he answer all of your questions?
Yes, ma'am.
Do you need any more time to talk to him before we proceed?
No, ma'am.
All right. Have you had any drugs, alcohol, medicine, any type of substance in the last 24 hours?
No, ma'am.
I have a score sheet, and it shows 109.5 total sentence points with a lowest permissible prison sentence of 61.125 months. Are there any objections or corrections?
No, Your Honor.
All right. Mr. Kuzer, did you review your score sheet?
Yes, ma'am.
Did you see any errors or problems with it?
No, ma'am.
Did everything look accurate to you?
I believe so, ma'am.
Okay. Is there any exculpatory DNA in the new case?
No, Your Honor.
I do find a sufficient factual basis based on my review of the arrest report in the new case. Mr. Kuzer, if you are not a U.S. citizen, do you understand you could be deported?
Yes, ma'am.
All right. Do you also understand that if you're adjudicated guilty of the controlled substances charges, and I'm looking at, well, I think you're already adjudicated guilty in the VOP case, but let me check. Yep, okay. All right, I'm looking at counts 1 and 2 in 25 CF 1514. If you're adjudicated guilty of either of those, do you understand your license, your driver's license might be suspended for a period of time?
Yes, ma'am, I do.
Are you admitting all 11 allegations that you violated your probation in 22 CF 829?
Yes, ma'am.
I accept your admission. I find it was freely and voluntarily made. And in case 25 CF 1514, how do you plead to counts 1, 2, 3, and 4?
No contest, Your Honor.
I accept your plea. I find it was freely and voluntarily entered. So this appears to be it's a plea to the bench. There's a score of 61.125 months. State prison, which is, that's above the maximum for a third-degree felony, and is there an agreement that that's a cap?
Even without agreement, it would be the natural cap, Your Honor. It's the most the court could sentence him to. It's the least the court without a downward departure could sentence him to. And I've had the conversation with Mr. Cooper
Okay.
as well.
Yes, ma'am.
Okay. All right, so then, sir, how it works, and I'm sure your attorney has gone over this with you, and we've already heard from the doctor earlier, is I'm going to listen to the evidence. You and your attorney are going to have a right to present evidence, and the state can present evidence if they wish, and then you can make whatever statements you'd like to the court. I will consider everything, and then I'll have to determine what an appropriate sentence would be.
Yes, ma'am.
Please know that unless the court finds that there's a valid basis for a downward departure and that it would be appropriate,
Yes, ma'am.
then I'm bound by the guidelines. You understand that?
Yes, ma'am.
Okay. All right, anything else I need to cover at this time?
No, Your Honor.
Okay, so let me see what the state wants to present regarding sentencing.
Your Honor, the state will only have argument. The state has no witnesses.
Okay. All right, Mr. Gates?
Yes, Your Honor, we would call Ms. Dana Paul, Your Honor.
Okay.
Just follow me. Just stand right here, face the judge, raise your right hand.
Do you swear or affirm the testimony you're about to give is the truth? If so, say I do.
I do.
Thank you, ma'am. Just have a seat.
You scoot all the way up to that microphone and move it if you need to, okay?
If you could say and spell your name right into the microphone, please.
Dana Claw, C-L-A-H.
Thank you. Go ahead whenever you're ready, Mr. Gates.
All right, Ms. Claw, do you run a program through the jail and at the jail?
Yes, sir.
And what's that program called?
Anchored program, Anchor Dorm.
Okay. What is the program that you run called?
Oh, Emerald Coast Life Center, ECLC.
And what exactly is that program?
So Emerald Coast Life Center is a trauma-informed, mental health ready to serve and support individuals that are in the justice system struggling with mental health or substance abuse.
Okay. So your program is designed to be a dual diagnosis type of?
Yes, sir.
Okay. During the course of running that program, did you get to meet Mr. Kuzer?
Yes, sir.
Okay. Did you interview him?
Yes, sir.
What were your findings based upon the interview?
My findings are is that he needs support. He needs people in recovery to connect with, and I think our trauma-informed mental health curriculum would be a great asset to his recovery.
Okay. You have two forms of that program, right? Out of custody and in custody, correct?
Yes, sir.
Which one was Mr. Kuzer approved for?
Either one.
Either one. And how quickly could you take him into that program if he was sentenced to that program?
We have space in our dorm inside jail, so right away, and then he can start right away on the outside as well.
In your review for Mr. Kuzer, did you review any sort of jail records for him as well?
I know he has been in and out of jail. I just interviewed him on what he was in there for now and what he was desiring, and that was support and recovery.
Okay. No other questions, Your Honor?
All right. Cross.
Say there's no questions, Your Honor.
All right. May this witness be released?
Yes, Your Honor.
Actually, I have a question or two. I need
Yes,
to
sure.
know more about so the in custody is only for jail inmates, correct?
Yes, Your Honor.
And the out of custody, is that a residential?
It's outpatient.
Okay, so it just provides services outpatient, not any type of residential
Yes, ma'am.
living, right?
Yes, ma'am.
Okay, I just wanted to make sure I understood, because I've heard of the program many times, I just didn't know the details. So-
Yes, Your Honor, and I'll follow up on that. I think you are intending to create an inpatient program, correct?
And outside, yes.
But you're not quite there yet.
We're not quite there yet.
Okay. But if the court was to set, check-ins and treatment, both mental health and substance abuse, that would be something your program is equipped to do.
Yes, sir. He has opportunity to be there twice a week for outpatient, and if he chooses to be there Sunday for Recovery Church as well.
Okay. And do you have licensed psychiatrists there to help with the mental health as well?
We have licensed counselors that we partner with, yes, sir.
Okay. No other questions, Your Honor?
Does the state have any follow-up?
No, Your Honor.
Thank you, ma'am, you're free to go.
Thank you.
All right, Mr. Gates, next witness.
DJ Atkinson, Your Honor.
All right.
Just remain standing right here, face the judge, raise your right hand.
Do you swear or affirm the testimony you're about to give to be the truth? If so, say I do. Thank you, sir. Just have a seat.
Scoot all the way up to the microphone.
Yes, ma'am. And then when you get situated, just say and spell your name right into the microphone.
My name is Donnie Atkinson, Donnie Adkinson.
Thank you. Go ahead, Mr. Gates.
How you doing this afternoon, Mr. Atkinson?
Pretty good.
Are you familiar with Mr. Kuzer?
Yes, sir, I am.
And how is that?
From jail, we hung out with the same rough crowd on the outsides. Basically involved in the same crowds.
How well do you know him after being released?
After being released, me and Mr. Kuzer, we stay on complete contact. Every day we speak. I've seen a complete growth in him throughout since I've been released. It started off of him wanting to be isolated to himself or, getting aggravated, stuff like that. But since I've been released, every day he's got a progress. He's been progressing every single day in his change. If y'all go back and look over the the footages from our videos on the phone, our phone conversations, you'll see the progress that he has made, that he has been determined to make.
Are you familiar with the ECLC?
Yes, I am.
And how is that?
Because I'm a member of ECLC.
How did you get that sentence?
Okay, so originally I was in here in front of Ms. Clark, Your Honor, on a violation of probation. I was looking at prison time. Your Honor, and the state allowed me to have the opportunity to prove that I was changing, because that's what I spoke that I was ready for. So they gave me the prime opportunity to prove that I was changing. Since then, I've not just completed all my requirements minus paying off my probation, the fees for my probation and stuff, but my community service hours completed with extra hours. I'm involved in my community positively. Got great outstandings with community control officers. No hiccups, no violations. I'm progressing every day. Every day is a whole new step. I've been through one phase through ECLC, completed the program like I was required by the court, and I'm still voluntarily going out there on my own, twice a week, plus on Sundays. Mr. Koser spoke about being dedicated to wanting to change his life. He's dedicated that's what he wants, is he wants to progress in life and he wants to commit to change. I was the same person. I was Mr. Koser. We hung out with the same crowds. We both suffer from drug addiction, and that's been our whole lives, drug addiction. We didn't have the role models and the support. We didn't have people that held us accountable. It wasn't until I gave myself up to Christ, and through ECLC and the grace of the judge and the state putting their faith in me, that made me change. Prison
So
doesn't.
it
yeah.
sounds like you're advocating for the E ECLC program.
I'm advocating 100% for ECLC because that's what changed my life.
And if Mr. Kuzer was to be released and sentenced to that program, would you ensure his compliance in that program?
Absolutely. He does, the day he steps out of the county jail, he does have full-time employment working for me and Bama Boy Construction. The owner of Bama Boy Construction's already said he's going to employ him. He's got housing, living with me full-time. He will go to his ECLC classes as required every week. He's said that he's dedicated to going to church on Sundays. So yes, I'm holding him up to full accountability.
And
Yeah.
what happens if he messes up? What are you going to do?
If he messes up, I'm bringing him right back to the county jail, period. That's end of the story, you know, because if he's dedicated to the change, he deserves that chance. You know, I understand, I'm not taking away from the wrong that he did. He violated. But me too, I also violated, but I was given that chance to prove that I was changed. And it was through the grace of God, ECLC, and Your Honor, and the state who put their faith in me and gave me the opportunity. Prison doesn't reform you. Prison puts you in a place that surrounds you with the same crowd of people that you was involved with on the street that you probably know from off the street. It's going to put you back in active use of addiction. And that's just how it is. If the courts wouldn't have gave me that opportunity to prove that I was ready for change, I would have been stepping out of prison still in active use. And I know that 110%. It was because of the grace and the chance and the opportunity to show that I was ready for that change, and through ECLC, that has kept me on my toes and has kept me steering straight.
If the court was to do community control with check-ins and all that, would you help ensure Mr. Kuzer?
Every Tuesday, on the day of the schedule.
No other questions, Your Honor.
The state might have some questions
Okay.
for you.
The state has no questions, Your Honor.
You've made my day, sir.
Yes,
Good luck to you.
And I want to say thank you too for you changed my life.
That would be your lawyer and
No,
the state
that-
and you,
That
but
was
good luck.
you give me that chance, Your Honor.
You're an inspiration. Thank you. All right, next witness.
Yes, Your Honor. I'd like to call Mr. Kuzer.
All right, Mr. Kuzer, you want to stay wherever you're comfortable is good. You can stay right there. You can come up here. Wherever you want to be is fine. And if you're comfortable right there with Mr. Gates, you're perfectly fine there, wherever you'd like to be.
Thank you, Your Honor.
And I think I swore him in a minute ago, so you're still under oath from when I took your plea,
Yes,
okay?
ma'am.
All right.
I think Mr. Kuzer would like to read a letter to the court if you may.
Sure, of course.
I understand like the severity of my charges. And I'm accountable. 11 months ago, I started this journey with nothing, with a bad attitude, a drug addiction, and no accountability whatsoever. And it was bad. I blamed everybody but myself. I thought I knew what I was doing on the street by trying not to go to treatment and thinking I could do it myself. I absconded, and I'm guilty of that. And I shouldn't have done it. And I self-medicated. I got caught with drugs, and I was again wrong. And doing this was out of my character of what it would be to recover. I used to be mad at the state. I used to be mad at Mrs. Howell, and they're just doing their jobs. Like, you know what I mean? I don't believe that anybody's personally biased against me. And it took me 11 months to realize that. Like, I have a huge family that's for me. I've been to prison 7 times since I've been 19 years old. Every time I go to prison, I do drugs. I try to bury myself in drugs and activity. I was in an organization. I'm not in an organization anymore. I don't do the things that I did, but it's still just as bad if I go. Like, every time I go, it's the same. I'm big on this accountability word because it's been thrown at me and I've batted it away for years. And it's my fault. Like, and given a chance to do this with a leash on me, with community control or some kind of sanction, or an actual family that I can reach out and say, well, I can't do it on my own. I've realized that I can't do this on my own. I can't do it on my own. And I don't know what else I could do. But given a chance, I mean, I'll try to make it. Like, I'll try to do it more than I ever did. I mean, I owe a lot to Travis Gates. My attitude has changed in a lot of ways. I owe Ms. Dana a lot. And I just asked to be given a chance, that's all. And that's it.
Thank you, sir.
Thank you.
Thank you.
Mr. Kuzer, early in your life, did you have any sort of mental health diagnosis?
I did. I was at Rivendell after my father died and after my mom died. Again, it's not an excuse though. But yeah, I had some tragedies, yeah.
Were you under any sort of narcotics at that time?
Not as a young age, but like later on, yeah, because of the Ritalin or the Vyvanse or the Xanax and stuff, yeah.
At the jail, have you had any sort of disciplinary reports for violent behavior or anything like that?
I haven't had not one DR. I haven't done anything.
And if the court was to sentence you to some sort of community control, would you abide by all conditions?
I would abide by all conditions and would want to succeed. I don't want any early termination. I just want to do all of it out like it needs to be done.
And if you given the choice, your preference would be ECLC?
Yes, sir.
And why is that?
Because I have DJ, I have Donnie Atkinson and his family behind me, and I have Dana, and like this is the only time I've ever been really like open. So like actually admitting that again, I can't do it on my own, and like I have people, and like you only get this one in a lifetime for people to be behind you like that, because like you can't make them do it. And like he tied on for me, and Miss Dana tied on for me, and like I just don't get it. Like, and I just don't get it from prison. They have drug treatments in prison. They're full of drug users. They're full of things that just doesn't exist. Like the treatment doesn't exist like it needs to be. It's just not structured like that. You know what I mean? It's just not.
No other questions, Your Honor.
Let me see if the state has any.
I have no questions, Your Honor.
All right.
Yes, Your Honor, I'd like to call Officer Hernandez.
Okay.
The judge, raise your right.
Do you swear or affirm the testimony you're about to give will be the truth? If so, say I do.
I do.
Thank you, ma'am. Just have a seat.
All the way up to the microphone, and move it as neat.
When you're ready, just speak and spell your name into the microphone for the court reporter, please.
Hannah Hernandez, HANNAHHERNANDEZ.
Go ahead, Mr. Gates.
Officer Hernandez, you aren't Mr. Kuzer's probation officer, are you?
No, sir.
Are you aware of what the recommendation in this case was?
Yes,
And what was that?
it was a period of incarceration is what it was on the VOP.
Have you talked with Officer Howell about this?
Yes,
And is Officer Howell the probation officer for Mr. Kuzer?
yes,
Has she made an amended recommendation?
yes.
And what would that be?
It was inpatient treatment is what it was.
Either at Phoenix House or ECLC?
Correct.
Was it her position that Mr. Kuzer would get high, get scared, and kind of run?
Correct, yes.
Was it her position that this really is going to be the last chance he gets for help?
Yes.
No other questions, Your Honor.
Does the state have any
The
questions?
state has no questions, Your Honor.
Thank you, ma'am. You can go back to your seat.
Thank you.
All right, Mr. Gates, anything further?
No, Your Honor, no further witnesses.
All right, let me see what the state wants to do. Just argument?
Just argument, Your Honor.
All right. So before we do that, let me just ask Mr. Kuzer if there's anything else he would like to say. I'm going to give you the last opportunity if there's anything else you want to add, sir.
Your Honor, I just I just want a chance to do what's right and to beat this addiction with other people behind me instead of going to prison again on another sanction. Like, that's all I ask.
Thank you.
Yes, sir.
All right, so the state can make their argument whenever you're ready.
Your Honor, while the state appreciates everyone being here today and providing their testimony, the state must look at this from a logical standpoint, and this is the reason why we were not in agreement with treatment. So the state's recommendation is the guideline sentence that is on the score sheet. This case cannot be viewed only through the lens of the current possession charges alone. The defendant has approximately 28 years of criminal history. He served multiple prison sentences, as you've heard today, and he's been placed on probation many times from 1998 through now. The state agreed to a downward departure in 2023 when the defendant already scored prison. He was ordered to complete a substance abuse evaluation and undergo any recommended treatment. Instead, he absconded and was not picked up until the new law violation that's in front of the court today. Your Honor, just want to go through the prior record briefly. So in 1997 and 1998, we have cases involving grand theft auto, burglary of an occupied dwelling, grand theft, and three charges of grand theft in 3 separate cases. The defendant was placed on probation and then violated with the new law violation. That probation was revoked and terminated, and then he was sentenced to 48 months in the Department of Corrections. He was released in what appears to be 2002. Then in 2006, we have the burglary of an occupied dwelling and grand theft auto, and then the offense that qualifies him as a violent felony offender in 06 CF 254, robbery with a weapon, which was reduced from robbery with a firearm. He was sentenced to 24 months in the Department of Corrections and was qualified as an HFO. He was placed on supervised release in 2007. In 2007, the defendant was charged with burglary of an unoccupied structure and then also was convicted of felony failure to appear. He was placed on 5 years of probation and then violated by absconding. He was then sentenced to 16.8 months in the Department of Corrections. He was released in 2008. In 2009, the defendant was arrested for felony petty theft and then a few misdemeanors, possession of paraphernalia, resisting without violence, and felony battery and lewd and lascivious, which was no props by the state. The defendant was sentenced to 48 months in the Department of Corrections. In 2013, he was released, and then in 2013, he was arrested in Broward County and was sentenced to 2 years in Department of Corrections for felony petty theft. He was released from prison in 2015. Then in 2017, he picked up a felony charge, which was reduced to 2 misdemeanor possession of paraphernalias and possession of marijuana. He was placed on 1129 probation. He was in violation for absconding and picking up a new law violation. In 2018, Mr. Cruiser was charged with possession of a controlled substance, possession of marijuana, resisting without violence, and driving on a suspended license. Due to his score, he was sentenced to 41.9 months in Department of Corrections. He was released in 2021. That brings us to the 2022 CF 829, where he was charged with possession of a controlled substance. That is the case that the state agreed to downward depart on, to put him on probation and give him another shot. And then he absconded immediately and was not arrested until the new law violation that is also in front of the court today, 25 CF 1514. Your Honor, the state is not arguing that treatment lacked value. However, we have to look at the pattern, the many previous violations, and the history of absconding and failing to appear. And for those reasons, Your Honor, the state asks for the guideline sentence to be enforced.
All right, thank you. And so regarding the, just to make sure that I'm clear on what the state's requesting, the guideline sentence is 61.125 months. So you're requesting that on, we're here on 2 felonies and 3 misdemeanors. You're requesting that sentence on each of the felonies?
On the felonies, Your Honor, and then time served on
Confirmed.
the misdemeanor charges.
Okay, thank you. I just want to make sure I understood. All right, and defense?
Yes, Your Honor. I think first we need to address the VFO designation. I think there's been no testimony that Mr. Kuzer has been a danger to the community. I think just looking at the score sheet, there's been no violent offenses since about 2006. I think the last quote-unquote violent offense was felony battery in 2009, which was an enhanced misdemeanor. So I think that goes to show that the violent charges are remote in time as compared to what's before the court now. Dr. Zeman did testify that he appears to be having no impulse type issues, that most of what he had was as a juvenile. I think before the age of 20, he was in prison, that he's kind of finally matured and is in a different mindset than he was. I would also say that the fact that he was accepted by both Phoenix House, ECLC, and Mental Health Court, but for the VFO designation, showed that he really isn't a violent offender. And as such, we'd ask the court to not designate him as a violent felony offender special concern. Moving to the sentence, I can't help but think of the one quote that the previous judge used to say all the time. One definition of sanity is doing the same thing over and over again and expecting different results. And that really seems to be what we've done with Mr. Kuzer. You score prison, go to prison. Score prison, go to prison. Score prison, go to prison. What was clear based upon the testimony from Mr. Kuzer and Mr. Zeman, Dr. Zeman, is there's no family out there. There's nothing out there. There's no support group. There's just Mr. Kuzer by himself. So I want the court to take this opportunity to maybe try a different approach with him, which would be an inpatient program, which would be ECLC, which would be Phoenix House. Those are all things that he's never had the luxury of doing. The court is well aware when looking at downward departure, the court has to find can and should. I think based on the testimony the court has heard, that Mr. Kuzer suffers from a mental health disorder that is not related to a substance abuse issue and is in need of treatment. It's exactly what Dr. Zeman testified to, that it was likely a PTSD, anxiety, bipolar, ADHD, he had all that was untreated as a young kid that would have led to a lot of those violent offenses he had as a younger kid, and then ultimately as he matured into potentially issues with substance abuse. So I think when you look at the cart and the horse, the mental health disorder was there prior to any sort of evidence of substance abuse, especially if the court looks at the criminal history that the state recited. Near as I can tell, the first really controlled substance related was the marijuana charge, I want to say 2013. The first felony narcotic charge was 2018. That's pretty much 20 years after his first felony offense. So I think that shows that the mental health disorder predated any sort of substance abuse. As far as amenability, I think Dr. Zeman testified that he was kind of taken aback by how Mr. Kuzer was, how proactive he was in seeking these options and talking about it and discussing his desire. So I think the court has competent, substantial evidence to find for a downward departure through the testimony, the report, as well as the score sheet the state referenced. Then we move to the court should. That's always that second part. And whether the departure is indeed the best sentencing option for the defendant in the pending case. Let's make that clear. The state talks about through the lens of all the cases. It's not what the case law says. The case law specifically says in the pending case. And what is the appropriate sentence in the pending case? Here, I would think is that inpatient treatment option, ECLC, Phoenix House. There's been no evidence that he's ever had any sort of prior inpatient treatment. There's been testimony today that both programs offer a dual diagnosis. The defendant, in his own words, has stood up, has taken accountability and asked for that shot. He knows full well if he messes this up, that's all she wrote. There is no other option. He's got a support group. You heard the court from DJ Atkinson come up and give a glowing recommendation for ECLC. Willing to be there for Mr. Kuzer, willing to support him. If he messes up, he said he would take him to the county jail himself. I don't know of a better person to have out there looking after Mr. Kuzer than that. I think the ECLC is a wonderful option as a sentence. I will tell the court in full candor, I had a gentleman, I don't know if the court members, Mr. Eric Gahan, while in jail waiting sentence, he actually did the ECLC, wrote me afterwards, after he'd been in DOC, in glowing recommendation. He wanted everyone to get that option in that program. I think that is what the court should do. The court should find that he's not a violent felony offender of special concern. The court should give the downward departure based upon the mental health disorder unrelated to substance abuse. He's amenable to treatment, and I think the court should give the downward departure based upon the testimony and evidence the court has. I will say the only evidence the state's presented is an unsworn argument, so if we're going to compare the evidence, I think the defense has done more than a wonderful job on that. Thank you, Your Honor.
Thank you. And I'll let the state have the last word, but then I might have some questions.
Nothing further from the state, Your Honor.
Okay. Can I see the attorneys up at the bench? I do have a couple of questions, just technical questions right now.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
Man, I got this. Let's roll.
Fight fire with fire, take one.
Have you been injured in an accident and need righteous representation? Call us, because we fight fire. Damn thing ain't working. Whoa! Not cool, bro.
I'm attorney Coy Browning. Personal injury is no joke. Just ask him.
Injured? Take a breath. Call Coy.
We're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briar Patch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area.
If you have not experienced the unique flavor of Crestview's Coney Island's burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3.
Technical issues with council.
Does the court want Mr. Kuzer to come to the podium for the sentence, or the court?
Wherever he's comfortable is fine.
Yes, ma'am.
And I'm just making some notes so that I don't forget anything about costs and things. All right, I have made notes. Hopefully I will not forget anything, so if I do, the attorneys can please remind me. As to both of the felony counts, it's count 2 in 22 CF 829. That's the charge that Mr. Kuzer is on probation for in that case. And then it's count 1 in 25 CF 1514. Well, first of all, there's an adjudication of guilt. There's already been one in the 2022 case. There's an adjudication of guilt on all 4 counts in 25 CF 1514. Back to the 2 felony counts. That's the only count that Mr. Kuzer is on probation for in the 2022 case, and it's count 1 in the 2025 case. The court has found and finds that there is a basis to downward depart, and as the attorneys know, this is extremely rare for me to do. I find it's appropriate to downward depart. The basis would be that the defendant requires specialized treatment for a mental disorder that is unrelated to substance abuse or addiction, and he is amenable to treatment. I heard the testimony earlier this morning from Dr. Zeman, who also submitted a report, and I found that testimony to be credible. So I do find that the defendant has proven that basis for downward departure, and that in this case it is appropriate. Now, Mr. Kuzer, probably at any other point in your life, if you had come before me, I probably would not find it's appropriate.
Yes, ma'am.
But from what I've heard and seen, it sounds like you have made a change, and I want to give you that opportunity to maintain it and to change your life.
Thank you, Your Honor.
Yes, sir. So I'm counting on you.
Thank you.
Okay.
You got it.
And I know you can do it.
Yes, ma'am.
So here's the sentence.
Yes, ma'am.
As to counts 2, 3, and 4 in the 2025 case, that's time served. So we're only dealing with the felony counts, 1 in each case. I am revoking and I guess I'm going to revoke and terminate, but then sentence to a new term of supervision in the VOP case.
Yes, ma'am.
That's what I'm going to do. That's 22 CF 829. So revoke and terminate, and then sentence to the sentence I'm about to announce. And then in 25 CF 1514 on count 1, it'll be the same sentence concurrent. You're going to be placed on community control for a period of 2 years. That's house arrest.
Yes, ma'am.
You're going to have a GPS. That'll be attached prior to your release at the cost of $1 per day.
Yes, ma'am.
I'm waiving cost of supervision. I hope probation's okay with that. But that's $40-something a month that you would have to pay for cost of supervision. Since you're going to have to pay for a GPS, I'd rather you use your money for that.
Thank you.
After you've completed the community control, you're going to be on drug offender probation for 3 years with a curfew. And that curfew, is it, Mr. Gates and Ms. Giardina, is it a 12-hour curfew or an 8-hour curfew?
Yes, sir. Yes, sir.
12,
Typically
9.
7 to 7.
7 to 7, but that can be modified by your probation officer to accommodate your work schedule. If you have to go to work earlier or stay later, they can work with you on that.
Yes, ma'am.
You will be randomly drug tested throughout your supervision at your expense, no less than twice a month. You must continue to participate in ECLC on an outpatient basis.
Yes, ma'am.
You must live with Mr. Atkinson for as long as he is willing to have you.
As long as it takes.
Right. You're not forced to have him live with you, sir,
Yes,
but
ma'am.
as long as you're willing,
As long as it takes.
then
Thank you, Your
that'll
Honor.
be your residence.
Yes, ma'am.
If you need to move for whatever reason, you've got to let probation know or your community control officer know.
Yes, ma'am.
And if something needs to be modified, of course, they'll send me the appropriate documentation and I'll modify if we need to change that.
Yes, ma'am.
I'm also imposing a suspended sentence in each case on the felony counts. It's a suspended prison sentence of 61.125 months That's your guideline sentence. If you comply with your supervision, and I know you can do it,
Yes, ma'am.
you will never see that sentence imposed, that prison sentence.
Thank you.
If you violate, Mr. Kuzer, and I hope you do not, I hope I never have to see you in this courtroom ever again.
Yes, ma'am.
But if you violate, you come before me, I'm going to impose the sentence
Yes,
if I
ma'am.
find that you've committed a violation.
I understand. Yes, ma'am.
So, just know that.
Thank you.
Yes, sir. The court costs are going to be in 25 CF 1514, $615 plus $100 cost of defense plus $50 application fee. In the 2022 case, $100 cost of prosecution, $100 cost of defense. And one of the things that I told the attorneys when I was talking to them up here is, it appears, and I don't know you, sir, just from what I've heard today and just seeing you in court and reading in your court file, but it appears that for the first time, you're truly of a mindset of wanting to change.
Yes, ma'am.
And if I hadn't seen that, then I would not be imposing this sentence. I'd be imposing the guideline sentence.
Thank you.
At a minimum.
Yes,
So
ma'am.
I'm going to give you that opportunity.
Thank you, ma'am.
Yes, sir. And so if you're serious about changing, here it is.
Thank you, ma'am.
So
God bless you. Thank you.
I want you to be an inspiration to other people. You
Thank
can
you.
do that. You
Yes,
can do
ma'am.
some good.
Thank
So-
you very much.
Yes, sir. You will have 30 days to appeal the order of the court in both cases, and if you can't afford a lawyer, I'll appoint one for you. And let me ask the attorneys, have I left anything out or failed to cover anything?
No, Your Honor.
No, Your Honor, I was clarifying on probation to make sure there's no issues on that sentence, and that it won't be an issue, and they said there was no issues on that, so we were good to go.
All right, so is there anything else holding you in jail other than these two cases?
I don't believe that I have anything else. No, ma'am.
Okay, so you've got to have the GPS put on before you get out. I don't know if that can be done today or not.
Okay.
So
Thank
it's
you.
already 3 o'clock. By the time you get back up to Crestview in the jail, you know, because we got a lot more inmates to go through, it'll probably be tomorrow. But see Officer Hernandez before you leave the courtroom, and then you need to be at probation tomorrow after you get out.
Yes, ma'am.
You need to go straight there, okay?
Yes, ma'am. Thank you.
Good luck to you, sir. Thank
I know
you.
the court said tomorrow, but within that day of release.
Yes, yes. Whenever he gets out, he needs to go to probation that day.
Thank you, Your Honor.
I'm just filling out the paperwork, and then we're going to start with some inmates who have relatives present. All right, we are ready for our next case.
Cheers, I got Mr. Manuel Dumas, resident of 21 CF 1599. If I could just have a brief moment for a signature.
Sure.
Nope, stay right here, Mr. Dumas.
Okay.
We still got to enter it.
Go ahead, let me,
And this is Mr. Manuel Dumas, 21 CF 1599, Your Honor. Violation of probation.
I was just trying to find, okay, here we go on the docket. 21 CF 1599, yes. Okay,
If I may approach the sign T form.
sure,
These were pointed out to misdemeanor counts only, so there's not a score sheet.
thank you. All right, sir, if you'll please raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth? If so, say I do.
I do.
Thank you. You can put your hand down if you'll just tell me your name.
Manuel Dumas.
All right, sir. You are here on allegations that you violated your probation, and I am looking at, let me just find it. I'm trying to find the affidavit. Okay, I found it. This is an probation. Am I looking at the right affidavit? It's from October 3rd, 2023.
That is true, Your Honor.
I think so.
He's been incarcerated and just recently released in April.
Okay, it's the 5th amended affidavit of violation of probation. It was filed on October 3rd, 2023. And that contains I'm sorry, 7 pages. All right, 24 CF 2949, and Mr. Brandon is present.
Your Honor, we have a plea agreement that's signed by all parties. It's on underlying misdemeanor, so it's misdemeanor DOP. There's no score sheet. May I approach?
Yes, thank you.
And I apologize, it is handwritten.
That's okay.
The court will see on the second line, I hope, that it's a revoke and terminate, and he will, D6 is DUI requirement.
Thank you, yes, thank you so much.
He was being supervised by JCS, by the way, Your Honor.
Thank you. All right, Mr. Brandon, if you'll please raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth? If so, say I do.
I do.
Thank you. You can put your hand down if you'll just tell me your name, please.
Cody Brandon.
Thank you. You're here on allegations that you violated your probation. I'm looking at the affidavit that was filed on May 20th, 2026. And have you had a chance to talk to your lawyer about those allegations that you violated your probation and any possible defenses?
Yes, ma'am.
All right. Have you discussed this agreement with your lawyer?
I did.
Did you read and sign the agreement?
I did.
Is that your signature on the back?
Yes, ma'am.
Do you understand the rights that you give up when you admit to violating your probation?
I do.
Is anyone forcing you or threatening you to make you admit the violations?
No, ma'am.
Has anybody promised you anything?
Say it again.
Has anybody promised you anything to make you admit the violations?
No, ma'am.
Are you satisfied with the services of your lawyer?
Yes, ma'am.
Are you admitting all of the allegations in the affidavit that was filed on May 20th, 2026?
Yes.
I accept your admission. I find it was freely and voluntarily made. In accordance with your agreement, the court does find that you're guilty of violating your probation. It looks like there was already an adjudication of guilt on the 2 charges in this case. Probation is revoked and terminated. All of the remaining DUI requirements will be D6, meaning that will go against your license. You'll have to clear those or complete those requirements before you can get your license reinstated. On each charge, you're sentenced to 60 days in the Okaloosa County Jail concurrent with credit for time served and credit for your Escambia jail time. There is, all right, let me back up. When I said 60 days in Okaloosa County Jail, it's just going to be jail. I'm not going to specify because there's no objection to transfer to Escambia County Jail, so.
And Your Honor, that's probably was unnecessary verbiage because my understanding, I was doing that because sometimes it's applicable. It turns out that last language is not going to be necessary because he's represented to me, he had already bonded out over there.
Okay.
So he won't have to, he's not on an Escambia hold.
Oh, okay, that's good. In addition to any previously imposed fees and costs and fines, there's a $100 VOP cost of prosecution fee, $150 cost of defense. That includes the application fee. All of your outstanding financial obligations, I think there was a previous fine of $1,000 imposed as well, if I'm not mistaken. Yes, there was, and a surcharge. I mean, there were other financial obligations that were imposed back when you pled in June of 2025. All of those, plus the ones I've imposed today, will go to collections if you don't pay them all off within 3 months. Did I cover everything, Mr. Newton?
Yes, Your Honor.
All right, and sir, you have 30 days to appeal the order of the court. If you cannot afford a lawyer, I'll appoint one for you. Good luck, sir. Thank you.
Vice President.
60, I just didn't want to specify Okaloosa. 60 days in jail. Thank you. I think I said Okaloosa jail at first, but I'm going to move it to Okaloosa. Okay, just jail with credit.
Your Honor, Travion Braxton is before the court.
All right.
He's got, may I say?
Yes, go
Case
ahead.
numbers 23 CF 126, 22 CF 2943, and 22 CF 739. Your Honor, the alleged victim in the underlying misdemeanor case is present in the courtroom. She's been here all day. I know she's spoken to Assistant State Attorney Gaynor. He has a docket day in that case on July 6th. Just from speaking today, I think that there may be a resolution of some kind imminently, maybe in the next day or two. But at this point in time, we're going to continue the VOP, and we would ask to continue the VOP, and hopefully we'll be able to bring him back pretty soon. If it's also possible that there'll be a way to resolve it, depending on what happens in the misdemeanor case, without him coming back. It remains to be seen. Right now, we need to move on for maybe a month from now, or as soon as possible after July 6th.
July 21st at 9 o'clock in all three cases for Mr. Braxton. That's 22 CF 739, 22 CF 2943, and 23 CF 126. And I believe they're all violation of probation cases.
Yes,
All right.
Your Honor.
Thank you. All right.
And his family's also been here all day, Your Honor.
Thank you to
Thank
everybody
you.
for your patience today.
Gregory Bruce is up next.
All right, Mr. Gregory Bruce will be out momentarily. That's 25 CF 1773. And he is present.
Yes, Your Honor. Mr. Bruce has a plea agreement that we've previously worked out.
Okay, and there's a Okaloosa County Sheriff's Office request for reimbursement for transportation.
Could you tell me the amount, Your Honor?
Sure, $195.60, 195.60.
Thank you.
Sure.
So I just wrote COT next to that amount, Your Honor. So
Okay.
do you see that? I wrote that cost of transportation down. It's being added to the agreement.
Yes, sir.
You want to initial by that box, just assuming that you're okay with that? Your Honor, this is going to be a revoke and terminate, so I'm providing the score sheet that the state has previously been provided. It's not a downward departure. May I approach with the...
Yes.
I'm sorry, Judge.
Go ahead.
Everybody needs to sign it. We've been over it, but he just does need to sign.
Okay.
I'll date it. Your Honor, may I approach with the
Yes.
signed agreement and score sheet? And by the way, his mother and other family member have been here all day. So thank you.
Sure. Thank you so much.
Thank you.
All right, sir, if you'll please raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth? If so, say, "I do."
I do.
Thank you. You can put your hand down if you'll just tell me your name, please.
Gregory Bruce.
Thank you, Mr. Bruce. You're here in 25 CF 1773 on allegations that you violated your probation. I'm looking at the affidavit that was filed on February 26th, 2026, and it has 8 allegations that you violated your probation. Have you had a chance to talk to your lawyer about those allegations and any possible defenses?
Yes, ma'am.
All right, have you discussed this plea agreement with your lawyer?
Yes, ma'am.
Did you read and sign the agreement?
Yes.
Is that your signature on the back page?
Yes, ma'am.
Do you understand the rights that you give up when you admit to violating your probation?
Yes, I do.
Is anyone forcing you or threatening you to make you admit the violations?
No, ma'am.
Has anybody promised you anything?
No, ma'am.
Are you satisfied with the services of your lawyer?
Yes, ma'am.
All right. I have a score sheet, and it shows 41.7 total sentence points. Are there any objections or corrections to the score sheet? Score sheet objections?
No, Your Honor, no objection.
All right. All right, Mr. Bruce, are you admitting to all 8 of the allegations that you violated your probation?
Yes, ma'am.
I accept your admission. I find it was freely and voluntarily made in accordance with your agreement. The court finds that you're guilty of violating your probation. Looks like you were previously adjudicated guilty of the charge. Probation is revoked and terminated. You are sentenced to 9 months in jail with credit for time served, and the court costs that will be imposed today, in addition to any that were previously imposed, are $100 VOP cost of prosecution fee, $150 cost of defense, that includes the application fee, then $195.60 to the Okaloosa County Sheriff's Office for cost of transportation, and you will have 6 months after you get out of jail to pay all of the costs and fees in this case before they go to collections. Once they go to collections, that would probably suspend your driver's license. You'll have 30 days to appeal the order of the court, and if you cannot afford a lawyer, I'll appoint one for you. Good luck, sir. Thank you.
All right, thank you.
That was Miss LaQuita Carter is the last name, Your Honor.
All right.
25 CF 1238.
All right, and she is present.
Yeah, that's fine. Judge, can we get the next hearing date with subpoenas?
Yes.
It's just the current offer, why don't you have a plea form, but we'll get a new date. All right,
I want.
So that would be July 21st at 9 o'clock. And I'll put it down for an evidentiary hearing. So for the state, we're probably not going to do the lengthy hearing first thing, so, I know you're going to subpoena witnesses, but probably not going to take this case right at 9 o'clock. So whatever time y'all can kind of informally agree upon to have the hearing during that day so that the witnesses don't have to sit around for hours.
Yes, Your Honor.
Okay, but July 21st at 9 o'clock is what the docket will say. That's your next court date.
Okay, excellent. That's our next court date. We'll talk privately. There's no offer today.
No, can I get your name? I don't know her your name.
It's in the paperwork we gave you.
I've never seen it, sir.
Okay.
Thank you.
Thank you. Casey France is up next. All right, that would be 26 CF 35.
Yes, Your Honor.
And she is present. And when I was reviewing the file, I saw that a motion had been filed. I just saw it last night to appoint an expert. So I will need a proposed order.
That was sent today, Your Honor.
Thank
You should have
you.
that in your inbox.
Okay. All right. I will go ahead and enter that order appointing an expert. What we probably ought to do is set the next court date for July 21st at 9 o'clock. and hopefully that evaluation will be done by then. So, ma'am, I'm ordering a doctor to come and see you, okay?
Oh, okay.
Yeah, and talk to you and see if there's some services that you need, all right?
Yes, ma'am. Thank you so much.
Thank you. We'll see you at your next court date, July 21st.
Thank you, Judge.
Thank you.
Terrence Cole is up next.
Yep. Yes, ma'am.
Mr. Cole.
Mr. Cole, thank you. No, you're good.
All right, Mr. Terrence Cole, I have case numbers 23 CF 942, 23 CF 1388, and 23 CF 2158.
Yes, Your Honor.
And he's present.
If I just have a brief moment, Your Honor.
Sure.
Thank you. Additional time. Your Honor, if I can get that 7/21 date with subs, the current offer is 21 months. It's a global offer. Client's not wishing to accept that today, so we can have that next court date.
All right, that would be July 21st at 9 o'clock for a contested VOP hearing. And again, just like I said a little while ago, I probably won't take a contested hearing first thing, so it's going to be on the 9 o'clock docket, but y'all might want to talk between yourselves, the attorneys, and figure out an informal time to tell the witnesses to appear.
Absolutely.
So that they don't have to sit around all day.
Yes, Judge.
Okay, thank you.
Right this way, sir.
Yeah, with you. All right. Yep, you're welcome.
Judge, I'm sorry, I'm not here.
I think it's Mr. Fleischman, possibly?
Yes, sir.
Gavin Fleischman. That is 25 CF 640, and he is present.
Yes, Your Honor. If I just have a brief moment. Sure. For additional time, just went over the current offer with my client. If we can get that July 21st date at 9 a.m. with subs, Your Honor.
All right, that would be July 21st, 9 o'clock for a contested hearing. And again, now I'm going to sound like a broken record, but I need to say it for each case, just if the attorneys could talk amongst yourselves and figure out an informal time to have that hearing to tell the witnesses to appear. This will be on the 9 o'clock docket, but I would probably not start with evidentiary hearings right off the bat at 9 o'clock. I'll take quicker cases first. So sometime that day we'll get to it, but it will be on the 9 o'clock docket.
Yes, Your Honor.
All right.
Right this way, sir.
Thank you, sir.
Marquise Bondville is up next.
All right. Marquise Bondville, 23 CF 2231. And he is present.
Your Honor, just a brief moment. Sure. Just a little.
Thank you.
Judge, if I could also get that 7/21 date with subpoenas.
All right. That is July 21st at 9 o'clock for a contested hearing. All right.
Thank you,
We'll
Judge.
see you then. Thank you.
Jonathan Freeman is up next.
All right, Mr. Jonathan Freeman, 25 CF 2406.
Yes, Your Honor. And if I just have a brief moment. Sure. Come here, Mr. Hold on a second. Judge, if I get that same day from Mr. Freeman,
All right.
July 21st at 9 with subpoenas, Your Honor.
All right, July 21st at 9 o'clock for an evidentiary hearing with subpoenas. All right, we'll see you then. Thank you.
Thank you.
Oh, he needs to enter a denial.
Oh, I apologize. It is his arraignment date. We'll be entering denial this,
Thank you.
this afternoon.
Do
Thank
you
you.
want me to read the
Negative,
affidavit?
we can waive for all formal reading.
Okay, thank you. No, I said July 20, hopefully I said July. All of them were July 21st. Did I say August?
I thought you did.
I thought July, I said August?
I thought she said.
Oh, I apologize.
If I did,
For Fonda.
Okay, July 21st on everybody?
Yes, July. If I said August, I'm sorry, it's July. July 21st at 9 o'clock for Mr. Fondle and for Mr. Frieden, who just left. All right?
That should be every day for me.
Let's see.
But I'll be staying in the courtroom, Judge.
Okay,
Up next is Joshua Anderson, that's from Mr. Medina.
I think we took care of this case already.
Okay.
All right, and this is
No,
Mr.
Mr. Anderson, I don't think he made an appearance today, Your Honor.
Oh, I mean, last week?
Maybe, but we have, I do have information.
Okay, this is
I was surprised to see him on the docket, but he's here, and it did give me a chance to talk to the state. Your Honor, I have received in the last week two communications from Ed Barbara with the Breaking Ground Ministries that has been very helpful in providing inpatient faith-based care. And they are willing to accept Mr. Anderson. The state is not prepared to accept that, at least at this time. I am going to continue to dialogue with the state on this. If we could have a continuance to not that far into July, hopefully we can get a resolution.
Well, we've already set.
We already said.
We heard the case. This is 24 CF 2376, and when Mr. Anderson was in court last week, that was June 11th. This case wasn't on the docket, but we took care of it then so that he wouldn't have to come back today. I'm sorry, had to be brought back again.
Did we say 8/10?
It's August 12th. So there's a new law case, 26 CF 824. That was on the docket last Thursday. And so both cases are set for August 12th at 9 o'clock. So you can bring Mr. Anderson in early if you wish. You know, if y'all work something out, there are dates.
July 17th?
I would rather him be on in August. The state's not gonna be prepared to accept probably any offer in July. He was on probation for a DUI and committed a new law DUI. So I'm not gonna be ready to resolve the case in July.
Okay. So we've already set both cases for August the 12th.
Yes. Thank you, Your Honor.
Okay, thank you.
Right this way, sir. Jackie Brooks is up next.
All right, so Mr. Jackie Brooks is present. This is 25 CF 1140. There is also another case, 25 CF 1007. I didn't find that one on the docket, but there are two. Go ahead.
I didn't have a file for that, Your Honor. I'm sorry. What was the other number?
25 CF 1007. There's two VOP cases. 25 CF 1140 is on the docket. 25 CF 1007, I could not find it.
Just gonna look to see if it's in the VOP document, Judge.
Okay.
And I did include that case in the score sheet, Mr. Medina.
Oh, you did include it?
Yes.
Okay.
The warrant includes both cases as well, and the affidavit. And
Yes, Judge, will
It's the battery.
so that's the primary, and what I need to do, Judge, it'll just take a minute, but we have an agreement, and I just needed to list that case. It'll just take a second.
Sure.
Doesn't change it was already in the score sheet.
Okay.
For some reason, it wasn't, I didn't get a file for it.
So Yes.
In that 25 CF 1007 case, it looks like he's listed as no attorney.
Ah,
Oh, that's why.
Might have been an error, which is-
where it didn't load onto the docket or something?
We had an issue for him who was scheduled for today, just unfortunately he did not make it onto the document.
Okay. So, let me look. I am appointing Mr. Medina,
Thank you, Your Honor. And
Yes.
And it's
or the
readily.
Public Defender's Office on this case. Okay.
And the state was already anticipating was resolved as part of this, I just didn't know about it, so I've written it in. You see where I wrote it in? That was that charge there. Remember that one we put out? It was part of.
It was all together.
Yeah, it was all part of this, yes, sir. But it just, I didn't have a file, I don't know why. I don't know why, it wasn't.
Well, I think it's because that 1007 case, it didn't make it to the docket. There was a computer
Yes, just.
issue, I think, and
Yeah,
it
we
didn't
have
make it
an
to the docket.
agreement, and if I may approach with the.
Yes.
I'm sorry, he has to sign it still. Sorry. Thank you.
You go, Mr. Medina.
Thank you. Your Honor, I'm approaching with the signed DOP agreement and score sheet. Your Honor will note, he does score that this is a downward departure with a legitimate course plea bargain.
Okay.
It's going to be a revoke and terminate.
Thank you very much.
Sorry. Judge, can I give a moment to the state probation to send this my photocopy of the
Sure.
agreement?
I have to sign and fill out the score sheet. I'm just doing that. Do you need the agreement?
No, Judge, I made
Okay.
a copy on my phone.
Okay.
Probation needs a copy, and they're going to send it to themselves. I apologize. Thank you. Thank you, Your Honor.
All right. Sir, if you'll please raise your right hand, do you swear or affirm the testimony you're about to give will be the truth? If so, say I do.
I do.
Thank you, sir. You can put your hand down. You're here in 25 CF 1140 and in 25 CF 1007 on allegations that you violated your probation. I'm looking at the affidavit filed on March 27th, 2026, and it has 5 allegations that you violated your probation. Have you had a chance to talk to your lawyer about those 5 allegations and any possible defenses?
Yes, ma'am.
Have you discussed the plea agreement with your lawyer?
Yes, yes, ma'am.
Did you read and sign the agreement?
Yes, ma'am.
Is that your signature on the back page?
Yes.
Do you understand the rights that you give up when you admit to violating your probation?
Mm-hmm. I do.
Okay. Yes, Mr. Medina.
Your Honor, I wanted to note that because I had written in that second case, I failed to note that there would be $100 DOP fee in both cases.
Yes.
And that changes the PD fees to be
$250.
2 100s plus a $50 application, so it should be $250 total.
I wrote that on here.
Thank you.
I'll write off to the side.
You understand? That's going to be 200 and 250 instead of 100 and 150.
All I wrote it off to the side on this first page. All right, sir, I think I was asking you, do you understand the rights that you give up when you admit to violating your probation?
Yes, ma'am.
All right, you understand you're giving up your right to have a hearing and make the state prove that you violated?
Yes, ma'am.
Is anybody forcing you or threatening you to make you admit the violations?
No, ma'am.
Has anybody promised you anything to make you admit the violations?
No, ma'am.
Are you satisfied with the services of your lawyer?
Yes, ma'am.
I have a score sheet. It shows 48.8 total sentence points with the lowest permissible prison sentence of 15.6 months. Are there any objections?
No, Your Honor. And, Your Honor, I would note, he explained to me that a lot of his points came from a long time ago, but I've also explained that the way that it works is if you had anything in the last 10 years and then you get something more, which he's done, is that it brings all those old things up. So it's appropriate to gather in those old points, unfortunately.
All right, sir, are you admitting all 5 of the allegations that you violated?
Yes, ma'am.
I accept your admission. I find it was freely and voluntarily made, and in accordance with your agreement, the court finds you guilty of violating your probation. It appears there's already an adjudication of guilt on the charges in each case. So your probation, in accordance with the agreement, will be revoked and terminated in each case, and on each of the charges, the felony charges, that's count 1 in the case ending in 1007, and then counts 1 and 2 in the case ending in 1140. On each of those, you're sentenced to 11 months and 29 days in the Okaloosa County Jail, concurrent, meaning running at the same time, with credit for time served. Now, I have no idea if you have the same credit on each case, but whatever credit you have on each case, you would receive. There is a $100 VOP cost of prosecution fee per case and a $100 cost of defense fee per case. And then there's a $50 application fee that will be applied to 25 CF 1007. After you get out, you will have 6 months to pay all of the unpaid monetary obligations. That means the ones I imposed today and any court costs that were previously imposed when you were placed on probation. After 6 months, then all of the costs, if they're not paid, will go to collections, and that would suspend your driver's license until you pay them off. So you have 30 days to appeal the order of the court, and if you cannot afford a lawyer, I'll appoint one for you. Good luck, sir. Thank you.
Thank you.
Sean Gonzalez up next.
Your Honor, may I have a moment?
Sure. All right, we are here in, I'm going to call out the case numbers. Mr. Sean, is it Nadal?
Yes, Your Honor, Sean Nadal.
Thank you, sir. And you're here in 2019 CF 3479 and 2019 CF 3481 and 2019 CF 3491. And I have Mr. Medina present, I have Ms. Gaynor for the state, and where do we
Your
stand?
Honor, I think where we stand is probably the state needs to announce what it intends to request. I do note that basically the state's offer is significant EOC. I think it's over, what was it, over 100 months or something?
It's 117, I think 165 months.
And Your Honor,
It's his guidelines.
so Your Honor, I know we're not going to be in a position to reach a plea bargain, at
Okay.
least at this point in time. I think the state has its foot.
Is here in the state will be moving forward evidentiary hearing. Did we get with Miss Bailey to schedule that? It
How
should
long
be
do you-
short. It's a positive UA, so it's,
Okay, so, I mean, if we could do it in probably, I know I've set a bunch for that July date, but we can go ahead and set it for that July date as long as you think it's going to be,
from the state side, I will be no more than 20 minutes,
okay.
15 minutes.
So how about July 21st at, I'm going to say 9, but you've probably heard me say repeatedly that I probably won't start with the evidentiary hearings. It'll be sometime that day, so you might want to.
Yes, Judge, and I think the way Your Honor likes to do things is if the defendant is found to have violated probation, Your Honor would normally go right into sentencing. Is that the way?
I would, but if you requested additional time, then
May I
I'd
have a
certainly.
moment with you,
Yes.
Your Honor?
There we go.
I'm
Okay.
sorry, Judge.
Oh, go ahead.
He advises that his family, again, not prejudging,
Right.
because he has a right to a BOP evidentiary, but in the event that he was found to have violated his probation, he would probably want to call family that my understanding is may be able to appear by Zoom connection from out in California. Is that correct?
If
You
I'm
could-
allowed to, yes, I would appreciate it.
We would set a different time
Okay,
for
we
the
would need to
sentencing.
do a different-
If we need to have a
Okay.
sentencing, then, and you needed more time, I would just set a different day so you could arrange all
I
that.
appreciate you, Your Honor.
Sure. All right, so right now, July 21st at 9 for the contested hearing, and then we'll see where we go from there. But if you do end up needing additional time to have family
Thank you.
appear, we'll
And if-
make that happen.
That's with subpoenas.
With subpoenas?
Yes,
Yes.
thank you.
All right. Is that everybody on your docket except for Mr. Howard's case? Is that one that's going to be called last?
Thank you, Your Honor.
Thank you, sir.
Thank you.
All right, we have one case left, and thank you to those involved for your patience today. This is 22 CF 2185, Mr. Brian Howard, and he's present and approaching. And get my paperwork. Let me pull up the case too on my computer. This is 22 CF 2185. And I have Ms. Herndon present for the state. I have Mr. Howard present as well. And we were here in court a week ago, a little over a week ago, on June 8th, and at that time there was discussion about state wanting to depose the witnesses on Mr. Howard's second amended witness list, the one you filed on, well, it looks like, I take that back, not the second amended. At that time, it was just the amended witness list. It was filed on June 5th, and I saw when I was reviewing the case that one was filed yesterday, and that's the second amended witness list.
Yes, ma'am.
Let me see where we are on that.
That's correct, Your Honor. We received the amended witness list, I guess, yesterday at 2:24. So for the court's information and for the record, right now, it looks like we have 8 witnesses that are listed in Okaloosa County. Two of those are missing addresses. Witness number 8 is Christina Gray. There is a PO box number. We need a physical address in order to set that. Witness number 10 is Robert Davis. There is no house number. There is one witness listed in Santa Rosa County. There are 3 witnesses that are listed in Taylor County, Florida, one in Heard County, Georgia, and one in Fulton County, Georgia.
Okay, hold on. I'm so sorry. I was trying to write that down, so.
Sure.
I've got number 8, that's Christina Gray. It's a PO box listed on the defendant's second amended witness list filed on June 15th. And you need a physical address. The number 10 was Robert Davis. It has a street, Mount Olive Road, Crestview, Florida, but you need the street number.
Yes, that's
And
correct.
then you said that there were,
There is one witness in Santa Rosa County who is his former attorney, Bradley Johnson. We do have his office address, but we're going to have to coordinate the deposition through the Santa Rosa County Courthouse because he is pro se. There are 3 witnesses in Taylor County, all of which have physical addresses. We have spoken to the courthouse there. We are waiting on a return call for dates that they would be available to coordinate a room for us.
which ones are those?
That is
number
witness
1?
number 1, Samantha Lukens, witness number 2, Karina Howard, and witness number 6, Heather Howard. So those are between Perry, Florida and Steinhatchee, Florida.
Just one second, I'm getting caught up.
Yes, Your Honor.
You said you have contacted the courthouse there and
We
you're
have.
trying to coordinate a date?
We are, because they have to provide a date that rooms are available in order to do those.
Okay, just one second. All right, and then you said one in Georgia, looks like number 9?
We have 2 in
Oh,
Georgia.
2.
One is in Heard County, Georgia. That is number 9, Your Honor, Betty Caswell. We've spoken to the Assistant District Attorney there. She is going to call us back by noon tomorrow about coordinating either through their office or the courthouse. We have one witness in Fulton County, Georgia, number 11, Bree Bonifay. That has an address of 1333 Cider Grove Road. It is a business that is not identifiable. It appears, we don't know if it's open or not. The second address is a PO box in Atlanta, Georgia. So we actually need a physical address for her.
I think she lives above the business.
It did not appear to be a 2-story business based on looking at the map and then looking at the building itself. So we need an updated address for her, and she's witness number 11. We also have left a message for the Fulton County District Attorney regarding scheduling that.
Just one second. What was the county of witness number 9 in Georgia?
That is Heard County.
Heard?
Yes, Your Honor.
Okay. Okay.
And then finally, we have 2 witnesses, number 13, Dalton Reeves, with no address. I do not know what state or city that individual is located in, as well as number 15, Jill Morgan, also. I do not know what state or city that individual is in.
Okay, just one second. When I looked at the file, I've looked at it numerous times, but most recently, when I looked at the file, I did see that number 4 appears to have been deposed previously. That's Mr. Joe Persley. I found a deposition notice in the court file. Did that deposition happen? That was when you were represented by counsel.
I can't have contact with Joe Persley. I can't have contact with Dalton Reeves, so I couldn't tell you.
Okay, well, the reason I was asking is I saw a notice of deposition in the file, and it looks like he's already had his deposition taken back when Mr. Johnson was
And I do believe that it
I'm writing down. So let's go down the list. Number one is Samantha Lukens, and keep in mind, I don't know who.
yeah, she's in
almost
Barry. I'll have her here.
all of these people are. So you're willing to produce Samantha Lukens
Yes, ma'am.
here in Okaloosa County
Yes,
for her deposition?
Yes, ma'am.
Okay, let me write that down. Okay, what about number two, Karina Howard?
She'll be here.
Okay, you'll produce her as well?
Yes, ma'am.
Okay. Number three, Sandy Pursley.
I'll have her here.
Okay. And I mentioned, let me check with Ms. Herndon, as to number four that I mentioned a minute ago, Joe Pursley. Does the state have a transcript of a deposition of Mr. Pursley?
Your Honor, not that I have in the file. He had pending criminal charges, and while it may have been noticed at some point, I do not know that he was in fact deposed. We will double check it, but
Okay.
I have not read a transcript, and we did make sure that all of the ones that have been done have been ordered and transcribed and provided those to Mr. Howard.
Well, that, okay, because see, I don't get transcripts unless somebody files in the court file, and that doesn't typically happen. So all I could see was a notice, and then an amended notice, and then I think there were a few, in fact. Let me print them out. But, so it looked like he may have been deposed, but I have no way of knowing.
Right.
So, okay, well, then you mentioned a minute ago, sir, that you can't have any contact with him. So
With
you-
Joe Pursley, correct.
So you wouldn't be able to produce him. The state would need to subpoena him and make arrangements.
Correct.
Okay. So, let me make a note about number four is not actually deposed that y'all know of. And the state would need to make arrangements to subpoena. Okay. Number five is Bobby Pursley.
I can have him here.
You can produce him?
Yes, ma'am.
You're willing to? All right, let me write that down. Number six is Heather Howard.
I can have her here.
You'll produce her?
Yes, ma'am.
All right, number six. Number seven is Beverly Winter.
Yes, she'll be here.
You will produce
Yes,
her?
ma'am.
Number eight is Christina Gray.
She'll be here.
You'll produce her as well? All right. Number nine is Betty Caswell from Georgia.
She'll be here.
You'll produce her?
Yes, ma'am.
Number 10 is Robert Davis.
You'll have to get him here.
Okay, that's the one that there's a street but no street number.
I'll get you the physical hardcore address.
All right, let me write that down. So number 10, Robert Davis. Mr. Howard's going to supply or provide the street number, and then the state would need to subpoena and coordinate or schedule that one. So if you'll bear with me, I'm just trying to keep an accurate set of notes. Number 11 is Bree Bonifay from Atlanta.
Yes, ma'am, I'll have her here.
You'll produce her?
Yes, ma'am.
Okay. Number 12 is Autumn Morgan.
Well, that's the one that I was asking you about. She's actually in Sacred Heart Hospital. She's bedridden right now.
Okay.
That's the one that I was asking about the Zoom last week.
Okay, so you mean testify by Zoom or have a deposition by Zoom?
Whatever, I mean, the deposition's for y'all, that's not for me.
Not for me, but
For
for
them.
the state?
Yes, for them.
Yes.
Honestly, Your Honor, in the very limited circumstances where we have individuals that are hospitalized, the hospital generally is not going to allow that.
So they're not going to let a court reporter and people come in and gather around?
No.
Okay, so, sir, how are you planning for Autumn Morgan to testify at trial?
Yes, she's a big part of this case.
Okay, is she gonna, I mean, what, I don't want you to go into her medical situation or anything, but if she's hospitalized, is she expected to remain in the hospital for a while?
Yes, she's bedridden. I guess the baby's heart rate is high.
Oh, okay, all right. So how is, I mean, if somebody's going to testify on either side, then the other side has the right to take their deposition. So how is that going to happen? I mean,
I mean, drive to her. I'll get the address to where she's at. I don't know.
When's the baby due, approximately?
I think August.
Okay. I have no idea what the availability or the likelihood of a deposition occurring in a hospital would be.
Right.
That's for the parties to assess.
I mean, that is the issue, depending, generally, I think for liability purposes, Sacred Heart, in my experience, is probably not going to allow that to occur, especially if she is high risk. But if the board wants to come back to that, that's certainly something that we can address after we've gone through the others.
All right, I'll make a note.
And can we push her off until like the very last minute for y'all?
When you say y'all, you're referring to the
Them.
state, okay.
Yes.
So, yeah, depending on when the trial is, I mean,
Okay.
yeah. So let's circle back to her. Let's see if we can get through some of these others. Number 13, Dalton Reeves.
I can't have contact with him.
Okay, it says address is presently unknown. Do you have any idea what his address?
I can't get it to you.
You can or cannot?
I cannot.
Okay.
I legally can't get it to you.
How are you planning to have him testify for you at trial? If you can't contact, I mean, I'm just trying to figure out, he's on your witness list, meaning you're gonna call him. I'm just trying to figure out the logistics of that, because the state would have to have the opportunity to take his deposition.
Right, and I think the state should do their job and find his address. I mean, he's out there.
It's not their job to find the address.
It's their job to uphold the law.
Well, there's a discovery rule, I don't know if you've read it, about depositions.
I haven't read anything.
Okay, so if you're gonna call a witness, you're required to provide that witness's address?
I'll get him then.
Okay, so that they can take the deposition. state would, once they get that, they would have to subpoena that person and schedule the deposition. So number 13, you're going to provide the address then?
Yes, ma'am.
Okay. All right, and number 14 is Eliza Reed. I think she was previously deposed.
She is the victim in this case, and so she has been deposed. I don't believe that Mr. Howard can lawfully have contact with her.
Correct.
So I would not see a need at this point for the state to reset her deposition since she has in fact already been deposed.
All right, and then number 15 is Jill Morgan.
Yes, I don't know how to get a hold of her either.
Okay. It says,
I can find her address.
yeah, it says address presently unknown. So is that something you would need to
Yes, I'll get it.
provide? Okay. So defendant will provide the address, and then the state would need to subpoena that person and coordinate the deposition. Next is Mr. Bradley Johnson, that's number 16. And
We do have an address for him. I don't believe that, I mean, lawfully, Mr. Howard would probably not be able to get him here. Under the rules, we would be required to go to the county in which he resides in order to do the deposition. His office is located in Santa Rosa County. That is one that we have reached out trying to schedule a date so we can subpoena him, but we will have to hear back from the Santa Rosa County Courthouse Administration regarding setting a date for him.
all right, and number 17 is Judge Stone. But is the state planning to?
Judge, the rules would not allow that.
Are you planning to?
Yes, ma'am.
Okay. So the state's not asking to depose?
That's correct.
Okay.
We are aware of what the discovery rules and law allow.
Number 18 is Assistant State Attorney John David Smith. So I'm guessing the state's not seeking to depose him?
That's correct, Your Honor. The
Okay.
law also does not allow that.
Number 19 is a new one that wasn't on the one, it's not on the witness list of June 5th. It's Raven Crane.
Yes, ma'am. Evidence has come forth in the last 3 days with her, and it's very important that she's here. I'll have her here.
You can produce her
Yes,
if you're
ma'am.
willing to?
Yes, ma'am.
Okay. Okay, let me go through and back through and let's add them up. Looks like 10 witnesses of the 19 on the list that, Mr. Howard, you said you are willing to produce them here to have their deposition taken by the state?
Yes, ma'am.
Okay, and I'm just going to read out the names, make sure I didn't miss one. I've got number 1, Samantha Lukens. Number 2, Karina Howard. Number 3, Sandy Pursley. Number 5, Bobby Pursley. Number 6, Heather Howard. Number 7, Beverly Winter. Number 8, Christina Gray. Number 9, Betty Caswell. Number 11, Bree Bonifay. And number 19, Raven Crane. Those are the ones that you're willing to produce for deposition?
Yes, ma'am.
Okay, so, and Ms. Burden, you may have said this in the beginning, and I apologize if I missed it. Have you already been in contact with court administration here to get a room?
Your Honor, I have, and I have dates that are available. So with the 10 witnesses that we have now, looking at the available dates, August 11th, or a half day in the morning is available. I would think we potentially could do 4 witnesses during that date. The next date that they had available was August 13th, a half day in the morning. I would think we could also do 4 witnesses. The next available date after that was August 31st, which should allow us for the 2 that he would produce, and potentially there were 2 witnesses, Joe Pursley, who I'm assuming is still in fact in Okaloosa County if we need to subpoena him. That's witness number 4 for the record.
Okay, and that's one you'd need to subpoena.
Yes, Your Honor,
Okay.
as well as number 10, who is Robert Davis. Assuming that he is in Crestview, we could probably do his as well that day.
Okay.
So that potentially would take care of those witnesses for the dates and times that court administration has confirmed. The next date after that they were able to provide us a room was September 14th.
Okay.
And we could set the remaining, well, it's going to probably depend on where Dalton Reeves resides and where Joe Morgan resides.
Sir, do you have any idea if they're in Okaloosa County?
No, one of them's in Kentucky and the other one's just this side of, or the other side of Georgia.
Okay. Well, neither of those sounds like is in Okaloosa County, so.
Right. Potentially, I guess if Autumn Morgan has had her baby by then, we could do her deposition on September 14th.
Okay. So, let me, we said we'd circle back to her. So, assuming she's not in the hospital, is that somebody that you're willing and able to
Yes, ma'am.
produce?
Yes, ma'am.
Okay, so like after she has her baby and if she's medically cleared to show up at a deposition, is that somebody you
Yes,
would be
ma'am.
willing to produce? Okay, so let me make a note of that. I'm so sorry, I just realized probation is still here. Y'all, we don't need you for this. I should have said that from the beginning. So sorry. And Mr. Koch, are you standby counsel?
Yes, Your Honor.
Okay, so I
Yes.
don't know if Mr. Medina has anything else today.
I do now, Your Honor.
Okay.
If I may be excused.
Yes,
Thank you.
thank you. And I don't know about the state, Ms. Gaynor? Okay, thank you, have a good day. It just occurred to me that this is our last case, and so anybody that is finished, they can certainly reach out. Okay, so back to Autumn Morgan, and Mr. Howard is willing to produce her for deposition here in Okaloosa County?
Yes, ma'am.
After she's medically able?
Correct.
Okay, so that leaves,
Be all of them.
that leaves
We still still have to do number 16, which is Bradley Johnson. We will have to coordinate him in the county in which he resides or works. And then number 13, Dalton Reeves, who appears to be out of state. And number 15, Joe Morgan, who is also out of state.
Right. Did you say one of them's in Kentucky and one of them is where?
Just on the other side of Georgia.
Georgia.
Yes, ma'am.
Which one is in Kentucky?
Dalton's in Kentucky, and Joe's just on the other side of Georgia line.
So she's within the state of Georgia?
Yes.
So if if the state's going to be deposing them, you'd have to coordinate.
I should be able to get that.
Okay? When would you know?
Give me a couple days on that.
Okay, so, let me make a note of that. So possibly number 13 and 15 might be able to be produced here, and you're going to check on that. Then that leaves Mr. Johnson, and the state's already reached out to Santa Rosa to try to get that coordinated. And that looks like that might resolve.
It would outside of 17 and 18, Judge Stone and David Snell, that resolves the listed witnesses, assuming that they could be done. So we could have a conclusion date with the exception of Mr. Johnson of September 14th for the depositions.
Okay, and that's assuming everybody shows up and is, you know.
Yes.
Okay. So, Mr. Howard, those are, did you write down those dates by any chance, or
So, yes.
do you need a piece of paper?
Yes, if you got one.
Yeah, of course.
I didn't know if you would email it or what you would.
I don't get involved in scheduling depositions other than, this is the most involved I've ever been in scheduling a deposition in a case, right here. So, I'm not present at depositions.
Okay, so there was August 11th, August 13th.
I wrote down the dates, and Ms. Herndon, correct me if I'm wrong, I was writing them down as you called them out. I see August 11th, half a day in the morning, here in the, is it in the south end, this
Yes.
courthouse?
Yes, Your Honor.
Okay.
And that's for 4 people?
Yes.
And when you say half a day, what does that mean? Is that 9 to
That would be
noon?
9 to noon.
Okay, and so that's 3 hours of time. All right, then I wrote down August 13th in the morning, half a day? Same?
Correct, Your Honor.
Okay, and you thought you could do 4 witnesses during that time?
Correct.
Okay, then I wrote down August 31st, is that a half day in the morning as well?
That is half day in the afternoon, so
Afternoon.
that would be, I guess, beginning at 1:30.
Okay.
And how many people are you planning for that one?
I wrote down 4, but I don't know what the state's.
Yes, no, this is all pursuant to the, I mean, he had stated previously, Mr. Howard said that he could provide the individuals, and so that would be the last of the individuals. I mean, at some point, I don't know if the court wants us to do a notice of filing and just set the names for him to produce. We're still, those are the ones that we're missing the addresses on that he could not secure attendance on, so we're gonna have to subpoena Joe Pursley, Robert Davis.
Okay. So, and then the other date I wrote down is September 14th, and was that An all day or half day?
That it shows as a full day that the courthouse is available, and what we had discussed was Autumn Morgan, should
Right.
she be available?
Okay.
Dalton Reeves, who is residing in Kentucky, and Jill Morgan, who is in Georgia, if they are to be produced, those could be done on September 14th.
All right. And that would, I believe,
With the exception of Mr. Johnson, yes, that would take care of,
okay, so then Mr. Johnson, that's going to be in Santa Rosa County,
yes,
date to be coordinated with the court there.
yes.
Now, on these, the 11, as far as the people, do I just bring 4 of them up, or do you need to know which 4, or?
What we would, or not we, what y'all would need to do, or you, or whoever, there needs to be a notice of taking deposition. And so the state's going to be taking the deposition, is my understanding. So they would prepare a notice, but they would need to know, since you're producing them, which ones, so they can do the notice and put the names in there. So why don't we find a date for you to maybe fill in the schedule, so you can talk to these people and see when they're available to come.
Okay.
Because, I think they probably appreciate being coordinated with.
Right. Right.
And working with their schedule as best you can.
Okay.
Just a hunch. So what would be a good, I'm asking both parties this, what's a good schedule? Like, when are things going to be disclosed? What's going to be disclosed? Like, for instance, the addresses for number 10, Robert Davis, the street number. And then Dalton Reeves and Jill Morgan. When would be a reasonable time for you to provide those?
I should have it by the end of this week, by Thursday or Friday at the latest.
Okay, so, do you want me to build in a little more time?